words are axiomatic and are more germane now than ever before. At a time when our traditional legal structure and conventional approaches to administration of justice are being held hostage by the prevailing pandemic, it has truly become imperative that we emphatically engage in and diligently deploy some non-adversarial alternatives to dispute resolution. By the prevailing pandemic, it is needless to say, our current handicap has not only forced us all to recognize and realize that litigation is not the panacea it was perceived to be, but also that over-reliance thereon can actually be detrimental to the cause of justice. It would be pertinent to note here that the law of instrument, otherwise known as Maslow's hammer, is cognitive bias that involves an over-reliance on a familiar tool. As Abraham Maslow said in 1966, and I quote, "I suppose it is tempting, if the only tool you have is a hammer, to treat everything as if it were a nail. It is therefore critical," and I unquote, "it is therefore critical to understand that resorting to litigation at every instance is not apposite, and the same may not always yield a peaceful quietus to the discord at hand, for in the prudent words of Dorothy Thompson, peace is not the absence of conflict, but presence of creative alternatives for responding to conflict. Justice Sandra Day O'Connor, who was the first female member of the Supreme Court of United States of America, had urged and emphasized a similar idea when she cogently asseverated that the courts of this country should not be places where resolution of dispute begins. They should be places where disputes end after alternative method of resolving the disputes have been considered and tried. Consequently, the value of mediation as an effective tool for dispute resolution can be clearly evinced from the wide array of unique features clustered under its rubric. These features include severability, flexibility, party participation, consensus, self-reflection, preservation of ongoing relationship, and or peaceful termination of relationship, etc. Furthermore, it fosters peaceable and healthier interpersonal interaction in long term, thereby preempting the cause of conflict in the society. Moreover, lawyers today must embrace reality that as officers of the court, their raison d'etre cannot be defined by litigation alone. To that effect, Abraham Lincoln had aptly declared, and I quote, "Discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees and expenses and waste of time. As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough," unquote. Even the great Mahatma Gandhi, in his autobiographically famously titled "The Story of My Experiments with the Truth," has sagaciously stated that my joy was boundless. I had learned the true practice of law. I had learned to find the better side of human nature and to enter the man's heart. I realized that the true function of a lawyer is to unite parties, raven asunder. The lesson was indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of cases. I lost nothing thereby, not even money, certainly not my soul, unquote. The said merely educating legal practitioners, that said merely educating legal practitioners will not be enough. Clients and litigants must also be made to understand that if it is often to their benefit to trade hope for certainty, for as the French proverb goes, it is better to have a poor agreement than a good trial. E-mediation is therefore the need of the hour, and if necessity is the mother of invention, conflict is its father. To that end, Charles Darwin had therefore rightly pointed out that in the long history of humankind, those who learned to collaborate and improvise most effectively have prevailed. In conclusion, I believe that it is time for all stakeholders of our justice delivery system to acknowledge that we can no longer afford to wait for the storm to pass. This not only includes an emergent need for judges to proactively promote mediation in new as well as pending litigations, but also encompasses the necessity for enacting a dynamic legislation that inter alia encourages pre-litigation mediation in more spheres than just Commercial Courts Act alone, and which further seeks to make mediation at least as vogue as arbitration and litigation. We must thus learn to work in the rain for as the Victor Hugo, who famously said, "Nothing is more powerful than an idea whose time has come." I, for one, am a firm believer that propelling mediation as mainstream dispute resolution mechanism has now become desideratum, and that this may in turn hold the key to offering greater access to speedy and better quality of justice to large section of the citizenry during these trying times. With that, it is my sincere privilege to welcome His Lordship, my Lord Justice Sanjay Kishan Kaul, and all the speakers, participants, and members of the audience to what promises to be a highly enlightening, edifying, and enriching discourse on the contours of post-COVID mediation and the path that lies ahead. Thank you very much.
Thank you, Rakesh. With the permission of the chair, we now enter into the mainstream of this program. Good morning, good afternoon, good noon to everybody, all viewers, friends across the world who are participating in this webinar. Over a period of time, in the dispute resolution mechanism, it has been learned that the mediation is occupying an important position which it usually deserves over an adjudication process. This learning has been by experience, not by anything else, and wisely so, because the adjudication process, despite all its principles of evidence, principles, procedures being followed in finding the truth, at times unable to satisfy the parties who want to seek justice and to resolve a dispute amongst themselves. So therefore, the mediation is taking up place, and it's well-deserving place. Recently, all of us are knowing about most of the mediators, about the principles and the working of the mediation. But very recently, a worldwide crisis of COVID-19 has brought up new situations, and where we have to learn the new techniques, how to work, not only in mediation, but in life, while social interaction, while interacting with people. So, therefore, it has been decided that we'll have uh, a mediation session, a webinar on a post-COVID, and a topic which has been given is the charting the new path. Our first speaker, I'm introducing the first speaker is George Lim. George Lim is a chairman of Singapore International Mediation Center. He has been a lawyer for about more than 35 years. If I precisely say, this more than 38 years. He firmly believes that the mediation is the first option for any dispute resolution. And rightly said it recently in his article that it should be the first port of dispute resolution. So today, I'll be requesting him that he will express his views with regard to online mediation, how it is to be worked. And recently, he established a COVID-19 protocol, and to tell us about the rise and the threat for the same. So may I now request George Lim to express his views. George Lim.
Thank you, Jitendra, and namaste. I must thank the organizers for inviting me to this webinar. It is a great privilege. And this morning, Santan sent me a note to say that we've got 1,000 registrants, which I'm told has increased to 1,300. So that is fantastic by any measure. You know, but I asked Santan, what are you doing waking up at 5 a.m. and sending me this message? And he said, it's the passion of mediation. So thank you everyone here for being so interested and passionate about mediation. Okay, with the short time allocated to me, I've been asked to share my thoughts on maybe 3 topics. Okay, I'm just going to go back a little bit. Okay, not just post-COVID, but just go back a little bit in time. But first, on the growth of the use of mediation in India. And secondly, the mediation as the preferred mode of dispute resolution, which Jitendra alluded to just now. And lastly, the shift towards the use of online mediation, which I think my fellow speakers will elaborate on. So let me begin first on the growth of mediation in India. And I'm just going to ask my friend Rahul to just help me with some of the slides, okay? So Sriram and I have known each other for a long time. Sriram, do you remember when we first met years ago? And then I was in Delhi in 2015 at the ABA conference, and we had a little chat. And you told me, you were so keen on mediation, but it looks like it's quite difficult to get it off the ground in India. But fast forward now, okay, to last year, to this year, we can see a change, a huge change, I think. And I want to attribute that to the efforts and the contributions of people like you all on the panel, all my Indian mediator friends. I think the passion that you have put into mediation has now changed, has now turned the tide for India. So years ago, I think when you talk about mediation, people are not that interested. But today, there is so much interest. And this is happening all over the world, not just in India. And I would like to attribute part of that to the signing of the Singapore Convention on Mediation, because I was part of the Singapore delegation at UNCITRAL for 4 years when we worked on the Singapore Convention. But very quickly, I think some of you know this, and some of you may not. When we were at the meetings at UNCITRAL, I was asking the Indian delegates, will India sign the convention, which is all about enforceability of international mediated settlements? And the delegates said, look, we support it, we are interested, but it will take time in India. But to our surprise, okay, the signing ceremony was on the 7th of August 2019. 1 week before the signing ceremony, okay, we received news that your Prime Minister, Mr. Modi, had a cabinet meeting and had decided to sign the convention. This was just a week before the signing ceremony, which was fantastic news, okay? And I think it was not just about signing the convention, but about making mediation a part of the scene in India, which you are seeing now, because laws are being amended, Mediation Act is being formulated. So it must trickle down to the ground. Okay, so that was the first step for me. I was the first sign, which was really positive. Now, can I just go to the next slide, please, Rahul? So from then on, the ceremony, you see that your Indian representative signing the document. We had unprecedented 46 countries signing on the first day, which is a record by UN standards. Okay, 46 countries. The next slide, please. Yeah, and of the 46 countries, you will see that India signed, China signed, and the US signed. 3 big countries, okay, and for me, that is more than half the world's population. So that was the significance of it. There's so much interest on the ground. Since then, 6 other countries have signed. We now have 52 countries who've signed the convention. 4 countries have ratified it because you need 3 to bring it alive. And now we've had 4, and Belarus has said they will be also ratifying, and now we have the convention coming alive on the 12th of September this year. So from my perspective, I mean, we've been working with Indian mediators. You see those photos there? Justice Call, you are somewhere there on the bottom left picture, right in the center there. We've been working with you all, Sriram, and I can see the interest, really, okay, of mediation gaining traction. Next slide, please. Yeah. So from the perspective of someone who's been involved in the Indian scene, I can tell you that what's happening now is you have the support of government, you have the support of the judiciary, and the private practitioners. Okay, it's coming together, and that to me is the most significant thing. This will bring India forward in terms of the mediation scene. Can I have the next slide, Rahul? Okay, very quickly, in February this year, I was invited to an arbitration conference in Delhi. This was the ICA conference, and that's where I met Santan. And your chief guest was your Chief Justice. And there, it's an arbitration conference, but he spoke about mediation, and he talked about pre-litigation mediation. So for me, this is so significant, and I think you are now talking about it. This is happening on the ground. So the work that you have put in all these years, plus the momentum of the convention, I think now has laid the groundwork. So for me, this is the moment for India. The tide has turned, and I think you should look at it from that perspective. This is a momentous time for India. Okay, Rahul, we can end the slides, the sharing screen. I want to move on to my second point, which is really on mediation as the preferred mode of dispute resolution. This is a really difficult time for everyone. Okay, COVID-19. Who would imagine, that a small bug, okay, could turn the world upside down? It's caused so much havoc. But for those of us who are watching the scenes, that there will be a lot of disputes arising from COVID-19. And in Singapore, we say, look, there will be a tsunami of disputes. All right. And when we were preparing, I said, look, take a simple example of a landlord-tenant situation. Because of a lockdown, the guy can't run his shop, he can't pay his rent. Landlord has a mortgage to pay. What's going to happen? You're going to have a dispute. Okay. Construction disputes. You can't carry on constructing. What happens? You claim liquidated damages. We're going to have all these kind of disputes. And I think you've heard recently that GNC, big giant GNC, I think which has a shop in Delhi airport, has now filed for bankruptcy. So we see this value of disputes which are going to happen. But it's if you think about it, it's a different kind of situation because disputes have arisen now because, not because of the fault of one party, but because of the situation. And for me, that makes all the difference. So I tell parties, look, you can assert all your legal rights if you want to, but can we pause and can we think of a different way of resolving the matter? And for me, mediation is the preferred mode of dispute resolution, COVID time and post-COVID. Okay, why? Because now we need to think as a society, we need to think as a country. How are we going to manage our dispute so that we come out better and stronger? Are we going to fight it out, or can we talk it out? So pause there for a moment, but for me, this is the message that we all should be giving to society, to the public. Choose mediation now because it is a better way of resolving our disputes now, and it makes us all think of the community, think of the country, come out stronger as a people, as human beings. So that was a message. I did an article which was published in the newspapers. I shared with some of you, but I'm hoping that people all over the world, mediators all over the world, will send that message. It is a preferred mode. Okay. The last point, the shift towards online mediation. So I think because of travel restrictions, because of lockdowns, we find ourselves in this situation. Okay, and I think there are pros and cons. For me personally, a face-to-face mediation is still better in certain ways, because I think you then have a chance to really connect, to build rapport, to persuade. Okay, but I think the situation is such that we have no choice. And online mediation has its advantages as well. And we found that because sometimes when you're forced to do something, you learn how to do it in a better way. And we've done quite a number of online mediations all over the world, in Singapore. And we find that the advantage really is sometimes people are more comfortable speaking to you from the comfort of their home or their office. They're more prepared to open up. But we need different skills, okay? We need different skills because, like for me, I would not start with a joint session. I would start with a private session with each party first to build that rapport. I think you need to do a lot more preparation, preparing the mediators, preparing the lawyers. And you got to do it, maybe you got to do it in sound bites. You know, we used to do mediation one whole day, but it's hard for someone to sit in front of the computer for 8 hours. So I would perhaps do a couple of hours and do it over a period of time, number of days or weeks. It depends on the case. It depends on the complexity of the matter. So different skills are required. I think there is scope for us to learn and to improve. For us at SIMC, the Singapore International Mediation Center, we have launched a COVID-19 protocol, okay, a special mediation protocol. And we tell the community, hey, we are going to run a special scheme for up to the end of the year. Everybody is going to take a cut. The mediators are taking a cut. The center is taking a cut. Okay, come to us. The mediation is going to be done online, and it will be done quickly, cheaply, and effectively. As a center, we provide institutional support, which to me is actually very important. In other words, somebody from the center, someone who's familiar with the mediation process, will sit through the mediation, handle all the technical aspects. Because like Zoom, you know, you have breakout rooms, right? When you do your private sessions, we'll be moving people in the rooms, we'll be doing joint sessions, but we are going to assign someone to provide that service because, you know, a lot of our mediators are not that comfortable using technology, but we want to tell them, focus on your skills, focus on making the mediation work. We will get someone to assist you. And this has found a lot of support and traction. People are coming to us because of that. And they don't have to worry about moving people in the rooms and sharing screens or whiteboards. And you can focus on that. But it's not just the mediation itself, but I think the pre-mediation, the preparation, which is so important. So we actually walk through the mediators, the different steps. We actually prepare the lawyers. 2 weeks ago, we received a case, 6 parties, okay, from all over the world, from three continents, and they want to do an online mediation. So can you imagine the logistics, the preparation involved? But this is what is happening all over the world. So for us all, young or old, I think we need to learn different skills, the new tools, and embrace mediation, whether it's face-to-face or online. So for me, message is the tide has turned for India. Okay, for those of you who are interested, please go for mediation training. Go and get your accreditation. Pick up skills, face-to-face mediation or online mediation. This is the way forward. And I think with all your support, India will be much better, because for me, it's not just about solving a problem or dispute resolution. It is about access to justice. Okay, I mean, it is a form of access to justice. All over the world, people are tired of long battles, and they just want to have some form of justice. And I think mediation provides that. That's why I say it is a preferred mode of dispute resolution. So on that note, I'm going to end because I think my time is up. But I think my other panel speakers will speak more about online mediation, the various characteristics. But I just want to end on this note that my hope is that India will ratify the Singapore Convention, because for me that will be good for India, that will be good for business, and it will cement the use of mediation in India. So on that note, thank you very much for listening.
Thank you, George. Thank you, George. George just mentioned it about the numbers of viewers. May I just update it? I just received from a technical person that there are more than 1,300 registered viewers on Zoom, which are seeing live. Then there are about figures I have asked them to correct it for YouTube, for Live Law, and for Facebook. Possibly I have asked them to collect it, but 1,300 are sure for it. So just for that, possibly it may cost more than 2,000. Our next speaker would be Mr. Sriram Panchu. And Sriram Panchu is one of the father figures in Indian mediation scenario. He is the first one who has established the earliest court-annexed mediation center in Madras. And thereafter, way back in early 90s, when the mediation was in the earliest stages in India. So, and he's an acclaimed mediator. He is the only one mediator who has been recognized and appointed by the court to settle a disputes between the two states, boundary disputes among the two states in the country. There's Nagaland and Mizoram. Very recently, Sriram was appointed as a part of team to resolve a dispute of a long-standing dispute, a religious dispute, which was known as Babri Ayodhya land dispute, which has been resolved. Now, George has said about that online mediation is in process and it is going to take place. Sriram would say the skills of mediation which are there, how far they are to be expressed and to be utilized in an online process. Whether the confidentiality which is being considered to be a sacrosanct in a mediation, how far it will be compromised or flexible. And I would request him to play a special emphasis on ethical issues. In mediation, the ethical issues, how they are to be maintained. Over to Sriram Panchu.
Thank you, Jiten. Firstly, may I say it's a delight and of course a privilege to be part of this panel with such distinguished co-panelists. And I must thank Santan and Rajiv and Rakesh for this, and of course Jiten. Before I step into what Jiten has outlined, let me say one thing. That I think online mediation is now here to stay. It is not a COVID-related phenomenon in terms of time. COVID may go, COVID may cease, COVID may depart, but I think online mediation is here to stay. The strange thing is, we always had a facility of talking and working online. We've had it for quite some time. We've had Skype, we've had FaceTime, we've had Zoom. I've used Zoom, in fact, well before COVID, but it wasn't part of our operating world. And now just see how easily we have all adapted to online communication. Look at the number of webinars that are happening, which we take place, the number of other occasions. We have family gatherings online. We run other programs online. We do work online. So it's almost like, you're scared to jump into a pool. But COVID comes along and that bug pushes you into the pool and you're merrily swimming over there. So that is my comparison to online. Everybody's in that pool now and I think doing quite well. And I think it's going to stay with us. Now, having said that, let me also say that I think that for court matters, I think a pure online is not the easiest thing going, because courts have traditionally been very public arenas, very public settings, where arguments take place in full view of lawyers, clients, other lawyers, other people. It's a public setting, it's a public forum. And I think for us, it's especially old timers, I guess, it's not so easy to think of a court, getting more into hearing parties and lawyers in the particular case. Hopefully that will ease up and we'll go somewhere, I hope, to functioning to a more public setting. But I think online is worked very well for mediation. As much as it may have with adversarial litigation, online works well for mediation. Because mediation is essentially about, confidential discussions. It's about mediator discussing with the parties and the mediator discussing with individual party confidentially. So it is all closed door discussion. So that is why I say mediation is in fact quite well made for online. It is true that in online you do not have the immediacy and the directness of contact that you have when you're sitting with somebody face to face. You miss that. But I don't think it's too much of a loss, because if your technology is good and if your screen settings are good and you have good clarity, I think you can make up for that. Plus also I've heard many people say that there is a little cocoon of safety which the screen gives you. You're talking from your house, so you're not exposed to the other party which you would be in a mediation room, and therefore you have a little box of safety where you operate, and that can well help. I think George mentioned that as well. So as I said, I think it's here to stay. But this is the fourth factor in India, which is propelling, I think, the use of mediation. Factor number one, and I think it's the Singapore Convention, which is a very important factor. I'm not putting monetizing, because I think that has opened up the confidence to people that mediation agreements are now enforceable. They are enforceable whether entered into the country or whether you want to enforce them abroad. And that aspect of confidence, enforcement is, I think, one of the little niggling factor in people's minds. It's a very nice process. I might get a good agreement. How can I enforce it? Singapore Convention has shown that enforceability is just like that. You have it for the asking. The second big thing in India, I think, are legislation for commercial courts, where we brought in pre-institution mediation for commercial cases. It is true that we have said for the time being that, if you seek an interim order, you will not have to go through mediation. Perhaps that will be modified so that you can still get an interim order and then go for mediation. That is going to see a huge drive of cases to mediation tables. That one legislation will create, I think, the demand for mediation, the demand for mediators, because people will be trying mediation before pursuing commercial cases. Inevitably, that will, I think, also cause the need for supply of good, trained, expert, qualified, trusted mediators. The third is the Supreme Court's move to set up a committee to create a mediation legislation, and we are tasked with creating an overarching comprehensive mediation legislation, which will iron out the creases we have in current legislation and I think put mediation on a very firm footing. The fourth is COVID. And I think COVID has wrapped up these things and given us, I think, the opportunity to take mediation into one level higher. Because online mediation is now so simple and is desirable. It's pretty much the need of the hour. And I think that will, I think, propel mediation to a step higher. I've done mediations, for a long while. I've done online for a fair amount of time. This is Cole was talking about, I think, parties from different countries being able to assemble so quickly. And I just want to say that 3 days back, I had a call at 8:30 in the evening from some people. They said, look, we have a huge contract going. It's going to break apart now. One party is going to court tomorrow morning. Can you give us a session at 9:30? There are 6 of us. We are ready. Will you give us a session at 9:30? In 1 hour, they strung 6 people plus 3 advisors. There were 9 people on that call. And by the end of that conversation, they had averted the going to court and are now back on track talking about how they can, keep that contract going. So that is what online mediation can do. It can structure something as quickly as that. But rather than my speaking about, how online mediation works, I want to read something which a young mediator sent to me. And she shared with me her first experience in doing an online mediation. And I'm going to quote what she says. She said there is actually no difference. Online fits in, it qualifies to be face and face. Why is it that the presence of a screen in between takes it away from being face to face? All communication and facilitation skills remain the same. There was active listening, body language, parties vented their emotions, reframed, reflected, paraphrasing, BATNA, caucus sessions went smoothly, impasse claim was handled, ethics, impartiality, neutrality, self-determination were exhibited, BATNA was employed, trust and rapport built to work through mutual solutions, acceptable mutual solutions. This is a young mediator. Her name is Pushp Gupta. She practices in Delhi. This is her very first online mediation. And I cannot do better than to endorse this. And this is what a young mediator says, that this is how easily mediation fits. Online merges seamlessly into our mediation skills and practice. I completely endorse that because I know from fact and from practice that what she says is true. So let me go on to point number 2 of my presentation. As far as ethics is concerned, Jiten, I will say that the ethics are the same. Whether you're mediating, offline, online, the ethics are the same. Your responsibility to parties for the right of self-determination, your responsibility to be neutral, your responsibility to be bona fide, and to make sure that there is no abuse of the process. But I think in online, you have one more responsibility, and that is to ensure that people are able to understand and use this online facility carefully. And I think that's an extra responsibility the mediator has to take care of. It is not necessary that the mediator must do it himself or herself. I think we can have centers, court centers for mediation, as well as institutions which provide, assistance to parties and their lawyers on how to operate online mediation. And coach them before the case starts. Can provide them, while the matter is progressing, if they need any assistance, to be available for that. I also think that there is one area which mediators must be very, very careful of. A country of disparities. We have people who are well off, we have people who are not so well off. And we have disputes that well off people against people who are not so well off. We must be very, very careful that if we're using online, we do not disadvantage the weaker, the less privileged person. Because it is that person who may have less access, less use, and less familiarity with technical resources. And therefore, I think it is the job of the mediator to make very, very sure that there is no imbalancing out there. Number three, I would say that we should create a module for training for online mediation. And here I'm very proud to mention the work of a young group of lawyers and mediators in Bombay. They are known by the name of Pre-Solve 360. I must tell you, they are the ones who really are the outliers in this field. They started doing online mediation 3 years back. They're a young lot, and they started 3 years back, and they built up a practice and an expertise in just doing online work. And at my request, they have put together an online training module for training online mediators to provide training for online mediation. And I've gone through it, I'm advising them, and I think it's a good module. And to me, it illustrates that, how much of this energy and this dynamism is coming from young people. And that's a source of tremendous satisfaction to me. My third and last point, and I'm trying to go a little broader. I think here we are seeing signs of deep and fundamental change. The growth of mediation heralds something. I spoke about the Singapore Convention, about pre-institution mediation. Also, I want to touch upon the fact that arbitration is now becoming mediation friendly. Increasingly, we're getting ArbMed and MedArb and how the two can be utilized. And I think we are doing a very, I think we're doing a fairly extensive rebalancing, which COVID has enhanced. And I think that rebalancing is that we are moving to a legal system where we will come to the adversarial only if and when necessary. That till we go to that, we will try every other method of consensual resolution and less adversarial processes, perhaps like arbitration, but come to the real adversarial process only if and when necessary. In this way, I think we can take care of a whole lot of litigation, which is commercial, which is consumer, which is family disputes, which is about money and property, personal disputes, matrimonial, a whole lot of disputes, I think, can be taken up this way. And essentially, Justice Call said a few days back, these are not disputes which need the time and effort of judges to sort out legal issues. If you can sort out something without requiring a legal decision, then try and sort it out that way. Bring it to court when you absolutely need a legal decision for that case, for that dispute. So I think that shift will take place. We will go to adversarial only if and when necessary. I think even in adversarial, we will start weeding out people who come to court just for delay, for the benefit of delay, and who exercise unreasonable refusal. And I'll give you an example. A lot of rent litigation is because the tenants will not leave. They know it will take years for the case to get over. A lot of checks bounce because people will not pay. They think it will be years for the case to get over. Now, I think we need to have a system by which we have some kind of a neutral evaluation, perhaps by mediator, perhaps by a judicial officer. But if you have a neutral evaluation which says, well, this is the prediction of the outcome of this case. And if a party says, I will not accept that, I still want to litigate, then I think when that party is proved wrong, the court should penalize. The court should penalize by heavy interest. If you're staying on in a property, by making you pay more than market value, penalize those who refuse reasonable offers to settle. Because the message must go out. The court here is not for rent of people who can afford court fees and expensive lawyers. If you can sort out your dispute elsewhere, go there and sort it out. Too much justice, too much real justice awaits because of contentious conflict which is thronging our courts. And I think now we are going to see working towards that system where I think we harmonize our methods of conflict resolution. What is resolvable, we put into that resolvable category of mediation. We put other things through the basket of mediation and arbitration. And matters of pure justice, pure law, we take to the courts. That is a broader view which I wanted to bring to this table. Thank you very much. Can't hear you, Jiten.
Needs to unmute, I think.
Sorry. Thank you, Sriram. Thank you, Sriram. Thank you for enlightening us on the skills to be adopted during the mediation and the ethical issues which you referred. Our third speaker is Bran Spears. And Bran Spears is president of, at present, he is the president of Commonwealth Lawyers Association and a person widely traveled. So the organizing committee requested Mr. Bran Spears to address the issue of cross-border mediations because he has been a widely traveled person. So I would request Bran Spears to address with regard to cross-border mediations because he is also the part of the team of drafting the cross-border mediation regulations in European Union. Bran Spears.
Thank you very much, Jitendra, and good morning to all of you. It's a very great pleasure to be part of this event and to be among enthusiasts for mediation, who I have always found to be among the most pleasant colleagues to engage in discussion. And it is really great to see the amount of enthusiasm that this topic has created today. I understand there are people watching from many countries in the Commonwealth, and it's a great pleasure to harness the technology and be able to meet in this way. So I am speaking to you from Belfast in Northern Ireland. I am the president of the Commonwealth Lawyers Association following our conference in Livingstone, Zambia in April 2019. Our next conference is going to be in the Bahamas, and I hope that many of you listening will take an interest in the work of the Commonwealth Lawyers Association and will participate as members and take an interest in that conference. I also wish to add my thanks to Santan and to the Youth Bar Association of India for pulling this really interesting event together. I first undertook training as a mediator in 1996 in New York, USA, and brought back a very enthusiastic message to my home jurisdiction. And nothing moves terribly quickly in the law, but it is now, I'm pleased to say, 25 years later, that our Law Society has taken a floor of a building in Belfast to, if you like, present a mediation centre for our disputes here. And that, to my mind, is a very great development. It does take a long time for the mindset of lawyers to change. And we have already heard from Shiram and George about their journey to mediation and the time it takes. And I share the view already expressed that the time is now more propitious than ever for mediation to really take off. The theme of our conference in the Bahamas is sustainable justice. And I ask a question at the commencement of my observations, whether justice can be sustained when it is greatly delayed, and whether justice can be sustained when the expense of going to what traditionally has been regarded as justice is so expensive and out of the reach of so many people. Delay and expense are problems for sustaining justice, as is the definition of justice. And no longer can justice be regarded only as something delivered by a court. Many people will say that having experienced a mediation, they are no less served by the interests of justice than if they had been to court. So expanding the definition of justice creating a mechanism for getting access to that system more quickly and with less expense really plays well to the role of mediation. That there is an interest worldwide and across the Commonwealth in particular is very evident by those participating today. And only last week, I took part in a similar event involving colleagues in another huge legal jurisdiction, that of Nigeria. And on Monday, I will participate in a conference in New York, also on mediation. So I can confirm it is of worldwide significance and interest. And in the post-COVID environment, I detect a pent-up demand for people to get their cases on, to get them resolved. And with many jurisdictions functioning only at the most basic of levels during the pandemic, there will be a pent-up demand for all the cases that have been paused and delayed for the last 3 months, and all of the cases that will arise, as George has said, from the pandemic itself. So what is not to like about a process that can be arranged quickly, that can be less expensive than going to court, where the solutions are flexible and where the parties to the dispute take part in crafting a solution that works best for them and is better than the alternative. So the old normal of mediation is to have a venue and for the participants to gather. That can still be achieved in the new normal using technology. And I have conducted online mediations using Zoom technology. And if the internet connection is strong and the technological platform is good, I have found mediation online to be entirely satisfactory for everyone, the lawyers, the parties, and the mediator. Now, I know that some will say that the skills of mediation, which often involve a very personal interaction and eye contact and observing of people's body language and posture, that those all are to some extent lost online. And that is true to some extent, but they are not lost to such an extent that one can say a Zoom mediation is unsuccessful or is doomed to fail. There is a problem about the delayed reaction on an online mediation, and the instant response of people either smiling or frowning when it's delayed can be a little bit disconcerting. And if you're making a light-hearted remark to settle people's nerves, then it can be disconcerting to find that the facial smile that you get as a response is delayed. But these are all matters that can be become accustomed to. One can also benefit from the discipline of having one party speak at a time, because on a Zoom mediation, when everybody crashes in over the top of each other, that really does not work. And establishing the ground rules early about having parties listen to each other and speak and blaming it on the technology, in my experience, has created a great discipline to an online mediation. So I want to take up a point that George mentioned and to develop it. And it is that for an online mediation, preparation needs to be even more extensive than an old school in-person mediation. I have found that by creating an advance protocol for the conduct of the mediation, I have found that by speaking to the parties and their representatives in advance means that when the Zoom event occurs, there are no surprises. The technology has been practiced and rehearsed, and one can quickly get into the mediation itself. And personally, I do have an open plenary meeting where everybody is together on the same screen, and I have found that gives an opportunity for the people to some extent size each other up and look into the eyes of those on the Zoom call. I too have found that the participants are relaxed. There is something about speaking in your own office to a screen that enables you to be more open, but also to be more relaxed. And therefore, I think that in this post-COVID world, if the technology is right and the preparation is right, and some of the skills that I've alluded to are, one is aware of the need to develop them, I see a great hope and a great need for online mediation. So across the Commonwealth, there have been many developments. I hope that someone on this panel will mention the evolution of the legislation that I understand is coming through in India. But on the island that I occupy, the island of Ireland, although coming from the north of Ireland and therefore being part of the United Kingdom, I take a great interest in what goes on in the rest of the island, and there is a Mediation Act of 2017 in Ireland, in the Republic of Ireland. And by clause 14 of that act, it compels lawyers to advise their clients before issuing proceedings that they should consider mediation with their clients. And if you are obliged as a lawyer to advise your clients of mediation, does it not behove you as a lawyer to know something about mediation so that you can advise your client what it entails, what you might encounter, and what strategies to adopt during the mediation? So I find that that legislated obligation to advise is of interest, and the Act itself, the Mediation Act Ireland of 2017, is, in my opinion, well drafted and relevant and is something worthy of consideration. There is an organization in the European part of the world called the CCBE. It's the Confederation of the Bars and Law Societies of Europe. And I was honored to be the UK expert feeding in to a publication issued by the CCBE for lawyers and to enable lawyers to advise clients about mediation. And it takes the role of the lawyer as mediator, and the role of the lawyer as advisor, and the role of the lawyer as an advocate in a mediation. And again, I commend some of your observers to this webinar to take that into account, maybe reference that in their studies and in their comparative learning. I was also asked to assist in a consideration of a working group on legislation proposed in the Bahamas. And I make these comments not to say what an interesting life I have, although it is not my day job and it is a very great interest of mine, but it is to say that mediation is a global phenomenon, and the advantages of it are recognized globally and are making progress globally. And if Belfast can have a physical premises and an investment in mediation with online facilities to be built in, and if the Bahamas can consider legislation, and Ireland has already got legislation, and India is thinking of legislation, and the European Union has produced guidance for lawyers, then we all can take comfort from that. And in addition, take comfort from the fact that at a United Nations level, we have a Singapore Convention enabling internationally resolved disputes using mediation to have the agreements made enforceable. And that has given mediation, in my view, a status, and George can expand on that if there is time, a status equivalent to the New York Arbitration Convention, and it has given mediation a status very far removed from where it began in my career 25 years ago as being something a bit quirky, a bit alternative, a bit way out and wacky. And now it is serious. There are university professors involved in teaching. There are senior colleagues extolling the virtues of it. And in our post-COVID world, it seems to me that it is going to do nothing other than take off. Can I conclude by making an observation about the professionalism of mediation? That it is not something that is just, a spare time activity that people might have an interest in. These are learned skills. They are skills that need to be applied within an ethical and professional framework. And whether online or in person, those professional aspects ought not to be diminished or diluted at all. The mediator must have integrity. The mediator must hold the neutral ground and must not stray into advice or decision making. And we should not lose sight of the importance of professional integrity, of having proper technology, suitable venues, correct preparation, and by doing the job of mediation in a professional and skilled way, we will simply assist in its worldwide promotion and encouragement in those cases which are appropriate for mediation to have. My concluding remark is to say that in my 35 years of professional practice, there is nothing more professionally satisfying than having mediated an intractable case and brought the parties to a resolution that they are content with and which on any measure is better than the alternative. So from the Commonwealth Lawyers Association, I bring you greetings. And from my personal perspective as a mediator, I thank Santan and the mediators of the Supreme Court of India. And can I assure Jachindra and others who have attended Commonwealth law conferences that there will definitely be mediation slots for which we are looking speakers at the Commonwealth Law Conference in Nassau, the Bahamas in September. Thank you so much for your attention and for inviting me to participate today.
Thank you, Brian. Thank you, Brian. Thank you, Brian, for extending the invitation for coming for the 2021 Commonwealth Lawyers Association. Now, Justice Kaul, the chair of this webinar, needs to note he's a sitting judge of Supreme Court of India. And as far as the mediation part is concerned, his contribution is known as a judge of Delhi High Court. He personally contributed, we have seen him. After court hours, he used to visit the mediation center and just to see how the mediations are being conducted. That was at the initial stage. And gradually, the mediation centers established. In Madras, the Chief Justice, his contribution is well known. And in Supreme Court judge, we witness day in and out. And in a very recent matter where the family dispute was just settled just because of Justice Kaul's intervention, where he said that the parties must have a meal together. And the meal together was a deciding factor. And it broke the ice, and the family disputes resolved just like it. Justice Kaul, in India, most of the litigation, most of the mediation is a court-annexed mediation. We are still in a stage where the legislation has yet to take place. It is in the process. Pre-litigation mediation is only being legislated in one aspect, that is in commercial court text, where there is a pre-institutional, where the parties are settled and they are going to the court, and just before an institution, they go for a mediation. We would request that to address it about the Indian situation, about the legislative impact, legislative need, and the pre-litigation mediation, and what could be their center, what could be the center, and how the existing High Court mediation centers could be utilized for mediation centers, or it should be independent, what it will. Over to Justice Call.
Thank you. And firstly, let me express my happiness at being a witness to this successful collaboration between across the Commonwealth to find a solution to the problem we are all faced with. We look to a future beyond the present confusion ruling our lives, and how to encourage a dialogue about ways to streamline the dispute resolution post-COVID world. Let me first say that challenges pose often solutions. People start thinking, people start experimenting when difficult times are ahead. And I think this has been a period of introspection for people to look to solutions, not only for this period of time, but post that period also. I always begin normally by saying that, what is after all a judicial system? What is law? Ultimately, everything revolves from a fact that a society is a social aspect of living together, and norms for that have been evolved over a period of time. Slowly, it was given the form of a legal shape. But ultimately, the problem is that if resolutions have to take place, they must do in a manner which should largely be acceptable to everybody. Of course, there will be situations where hard decisions have to be taken and everybody is not on the same page. This pandemic has really changed our life and turned it virtual. Even the judiciary is undergoing revolutionary changes in embracing the internet. Arbitration is embracing it. And it is my belief, though Sriram mentioned that in adjudicatory process, it has a limitation. But the online processes will become certainly supplements even in better times ahead. So even if you look to an adjudicatory system, there have been talks often that the Supreme Court is too far away, should there be benches, there are views for and against this. But there can be a thought process that on what is known as a Monday, Friday admission day, the normal day can be supplemented with a virtual court so that people who would like to address from where they are or get lawyers from there are would save costs and also be able to get a right and opportunity to be heard. Same true arises, I think, for the arbitration process. And I think though we have debated the issue of the positives and the negatives in online mediation, the fact remains that mediation is a process which on an online process will certainly go on and would possibly in times to come may not be the only form, but certainly a major form in supplement, especially in respect of commercial disputes and cross-border issues. Let's understand the fact that the basic advantage of mediation is the ability to find solutions which are out of the box. So you're not constrained by the legal parameters of give and take the whole, nor are you prevented from collaboration, as often happens, where fighting parties become collaborative in business deals. That's the fundamental principle which is there. The online process which we are seeing today is arising from some countries immediately taking steps. Some before the set of COVID problems, some after. So you have a Hong Kong system where the moment the COVID started, they set up a system to deal with it. And then you have the Italian system which was set before. To my mind, the important aspect is that any dispute resolution should first begin by parties sitting together. And that's what the Italian system emphasized. Make sure that before litigation begins, the parties sit together themselves to sort out a dispute. I think a lot of progress can be made if parties are just across the table. And that should be a part of a compulsory process for the parties to sit before the litigate. As we have talked about some of the legislation in India, like the Commercial Act and some of the other areas where pre-litigation mediation has been labeled as an essential part. I think the second stage should mean with the assistance of a mediator, where you go in for a mediation, and if you on the first stage cannot sort it out, you are assisted to try to sort out the problem. Now, this compulsion has to be there to find a solution. We have so far worked on a system of an opt-in mediation. That is, are you willing for a mediation or not? Therefore, the Commercial Court Act and some of the provisions of similar acts were only brought in as a different innovation of an opt-out mediation. That is, you must first mediate, and then you have a right to walk out of it. No difficulty. You may say, I'm not able to find solution, but at least you'll sit together. And I think in this time where across the board, an opt-out mediation is necessary. The large volume of litigation which faces all courts in India, there is a small section which will require adjudication in court, maybe constitutional matters, maybe criminal law matters, and where legal implications are there. Unfortunately, the time available for them is reduced because a lot of other areas come before us, which can be mediated or arbitrated. And some of the people who practice have seen that even at the last court stage of the Supreme Court, there have been solutions found through a mediation process. Now, if we are able to set in process a motion whereby this is given a legal structure, I think it will be extremely helpful. So far, the Indian process has devolved on a basis that we will include certain provisions for mediation in different acts. So the debate was on of whether there should be a centralized legislation or whether there should be act-based mediation systems. The latter apparently wait with the government earlier. But there have been change of thought processes, and the government is looking also to a centralized mediation act. Mr. Sriram Panchu mentioned of the fact of the MCPC, which is the apex body in the Supreme Court, taking some initiative and trying to give an input to the government in terms of saying what could be a possible draft legislation for consideration. And this is receiving inputs cross-border, not only in India. Now, if you look to the current scenario, what is I think important is that the government is also looking to the aspect of an economic revival package, including a mediation process. Because as being said, a lot of litigation is going to be thrown. And if we are not able to resolve these issues quickly, there will be a problem. We are also faced with a situation where the financial ability of litigating parties is going to be affected in terms of the power to litigate. On the lighter side, not good news for lawyers, but the fact remains that there will be people who would like things to be sorted out. There's a second aspect, I think, we call it in the absolute power and almighty. The human race has been thrown into their houses, made to sit down and introspect how they behave in a universe or a world which is of different living creatures. And I think this introspection is bound to generate a thinking in people that fighting or battling it out should be the last solution and not the first solution. If we look to the two aspects of monetary effects and the thought process of these few months which people will apply their mind, I'm sure mediation can become the preferred area. There have been, in the arbitration also there have been changes. So we've talked about, say, spot arbitration mistake. What is the idea? The idea is a quick resolution of dispute. And that's what mediation is about. Of course, the challenges which we are faced with in the online process, some of them Brian discussed and said that, look, there are certain advantages and there are certain disadvantages. The disadvantage which I feel and I want to just put forth also is that sometimes the face-to-face warmth, the empathy may not be the same. And these are more dealing with family matters, I guess. But there is going to be a large explosion of commercial disputes where this aspect is less important, where the empathy factor is less, the understanding is more as to where the rub lies. That's what mediation is about, trying to find where the rub lies. Because if you don't get to what is troubling the parties, the solution which will be found may be palatable to one and not to the other. The advantage with the online mediation is that wherever you are, the mediation possible can take place and promptly take place. Otherwise, if people are in different jurisdictions, they will have to come forth from different jurisdictions and assemble. We had this possibility, I know of an example where ultimately a very old suit got settled only by the process of calling everybody who were based in different parts of the world to Delhi to fix a 2 months time gap and say, okay, you come here. And it took a couple of sittings to work it out. People had just not met. Now, that's the problem where people are set all over the world today. And this is true of all nations. Therefore, the online process facilitates the people to, one, work from their houses and have a discussion, which gives the confidence. And on the other hand, find quicker sitting and quicker solutions to the problem. Let me give an example which didn't work out, but that's not important. There were a family dispute where the patriarch, the grandfather, was sitting in the US. He was 90 years of age, and between the daughter-in-law and the grandchildren, and ultimately, as a court, we decided to have a sitting in the evening by finding a common time, and we talked to them, trying to find out whether a solution is possible or not. Issue is an endeavor is made to find a solution. And even if that mediation process doesn't work, you go to the next adjudicatory process of arbitration or litigation. But that does not mean that mediation is over, because there will be litigations which will start, but the really maturity of a particular nature of case for mediation may arise later. Sometimes it is litigation fatigue which sets in after a period of time. So there are various categories of cases which get settled. There's no fixed line for it. Sometimes it needs the initial, in a suit, it needs the explanation of their respective stands to come to know their weaknesses and strong points. So the mediation process starts at different stages according to me. What we should be looking for in this online process is that I would support a model where the parties must first be compelled to sit together, try to work out something. If that sitting together doesn't work out, then a mediator comes and steps in. And if the mediation also doesn't work out, then you go to an arbitration or a litigation, keeping in mind that the mediation process is even available as and when required in the litigative process. Sharma gave an example of something where he was appearing before us. And ultimately, it was just a little bit of push to send them to a meal together, the brother and the sister, and all the other family members to said, over the meal, they sorted it out. Point is, they did not meet. There were other people who interfere in the process that time, would not let things settle down because there would be stakes of other holders. The next generation may have stakes. So I think the important aspect is that if we have this centralized legislation to deal with it, and I feel this is the best of times in India for it, because if it is perceived not as a standalone thing, but perceived as part of a revival economic package, I think a legislation debate can take place at an earlier stage. And the aspect and the important aspect of India signing the Singapore initiative, of which he has been a very important part, I think sends the signal that there is a significance being attached to this, even in the pre-COVID period, and more so in the COVID period. Of course, in somewhere I had expressed to you that let us, as an online process, let us try to concentrate initially on COVID-generated disputes, because there would be commercial disputes, maybe easier for solution in the online process. What I didn't want to convey was that it's not that online process is not possible in other areas, but maybe the initiative to sort out what has been generated in 3 months and will be generated now quickly through an online process will prevent these litigations to come into the mainstream of adjudicatory process. And also because these people are already going through certain aspects of different problems, which I said, and find earlier solutions. If we are able to successfully find online mediation solutions to the current commercial disputes, I'm sure it will give an impetus for the mediation process online to do for all the others also. As and when normalcy is restored, normal mediation and online mediation can both go together, as is the situation for some areas of litigation. We have talked about these cross-border issues of and let me say I was involved with the with the insolvency regime also, being heading the Indian chapter of the Insolvent International. And for many years, the debate was, when will India go through a cross-border insolvency regime? It took many years to do so, but we are fortunate that in the mediation process, I think we may have an earlier regime, because the COVID is something which is not affecting India alone. It has affected business community across the world. And therefore, it is necessary that we find solutions to it. The importance and a problem which is faced always in mediation is, often people ask, what is the certainty of implementation, enforcement? Now, the regime which is being brought into force would take care of it to an extent. So the fact that people may be hesitant because they would feel that this is a wastage of time can be obviated to a large extent. And though debates have again in India gone on for a number of years, how mediation can be given a better enforcement. There have been talks of, recording the mediation settlements even in a sealed cover, because like an arbitration award can be registered, you can have a mediation award where a mediation authority looks into this. The advantage is we will have almost an international regime which is possible in this. So settlements which take place across regimes would be extremely useful. I also believe that mediation has to be taken up seriously as a part of the education curriculum also, to inculcate that problem in the universities. So the students who are coming out are prone to this kind of a solution. Sriram just gave an example in Bombay of young lawyers trying to find solutions through online process. Very encouraging that people think in this. And I believe that young lawyers who come out are always more idealistic in character. It can be somewhere destroy the ideology at times. So it's a time for taking advantage of this ideology to find solutions to the problem, rather than making only a monetary aspect out of it. You did mention that there is so far court annex mediation as an emphasis. No doubt true, in India it's been so. But there have been private mediation centers which have been set up. The court annex mediation will continue to play a role in kinds of mediation settlements where there may be smaller areas. So you're looking to a village level, you're looking to small town areas, non-commercial disputes, personal disputes. Sometimes the institutional mediation works better there. On the other hand, commercial disputes is one category where I think the private mediation has the greatest role to play and possibly the greatest interest they would have in this. Now, if we can do it subject-wise, both have a possibility and a role to play. And it is not necessary that it's either or between a private mediation system and the institutional mediation system. Of course, there will be issues of ethics which are there, which need to be touched. Online mediation, privacy issues, the other thing which has to be done. And as was being said by Lee, we have to also possibly go through a little retraining process in this. The retraining process is only that how you proceed with the mediation will require a little different setup in online mediation. One of the examples he gave was possibly begin with a caucus sessions instead of a joint session in the beginning to understand the parties as they are. Even as I talk to you people, yes, of course, you are right across my face in that sense. So even when I'm carrying out hearings through this process of virtual court, almost the person sits almost in front of me. It's a different experience, a different thought process. But we have to adjust our minds to these changes. We can't be stagnant in this process. And I think the COVID has given us an opportunity to go in this direction, experiment more with it, and try to find solutions through a mediative process, leaving the courts free to deal with serious legal issues. If these private mediations are there, the only thing is that their enforceability or their validity has to be examined. Therefore, if private mediation settlements take place, it should not be treated as an agreement itself. But if we have a methodology by which they can be filed with some authority, then certainly they can be enforced like any other process. I actually, seeing what Singapore has done, seeing what other countries have done, I'm looking forward with some great hope that the concerned authorities will wake up to a situation that economic revival will lead quick resolution of dispute. Quick resolution of dispute will need parties to sit together and go to a mediation. And if that is a possibility, then they must bring a centralized regime in force, which should help in bringing the process on. I would say that the ultimate one caveat which I have is Indian litigation crowding, if I may say so, is a little different from other countries. This crowding is a little different because the government is a litigant to the extent of over 50% cases in one form or the other in our courts. What I've said so far would be extremely useful for settlement of the private settlements. But the government must change its mindset. There must be a complete change of mindset to settle disputes. Unless that happens, because if we see the kind of disputes which will come, banking industry will be a party to it. Government economic activity will be a party to it. And they must therefore change a mindset, create panels which will help in settling government disputes in mediation. I understand the reservations which often the bureaucrats have in settling matters or in agreeing not to carry litigation further. They're concerned of not facing the repercussions a few years down the line where somebody challenges. That has to be taken care of. And I think the government must play ball and must also ensure that their part of litigation also settles as much as possible. I also believe even on the criminal side, plea-bargaining has not worked to the effect we thought it would. At least in lesser offences cases, a mediation and plea-bargaining can play an important role in this scenario and leave the courts for deciding serious criminal offence cases, constitutional law cases, principles of law where they're required to be laid down. And also in the process, judges give us time to introspect and deal with those matters rather than trying to play a T20 game all the time in the court. Let's get back to a test match in the court to be able to deal with those areas. In the end, I would say that I think the judges must also encourage mediation. That's a very important part. Judges must also go through a mediation themselves, I feel, because if the mediation is done by, training is done by them, and some of the places like Chennai and other places have gone through, I think they are better off as judges. I was fortunate that at a very at an early stage of my judgeship, mediation came to Delhi. And Sriram Panchu and Mr. Niranjan Bhatt were two people under whom I went through a training actually. So I did a training as a mediator at the first level, second level, advanced training, re-advanced training, and it's a constant learning process. So for me personally, I think it's a great way forward. I truly believe that it gives me more satisfaction to settle a dispute than possibly to write a very complicated judgment. Because by the end of it, there is a satisfaction that both sides go satisfied. I, as a judge, would find it very difficult to do that because the path which is followed, one party will always feel that the one party is won, the other is lost, and one has gained. Therefore, I have repeated this example. I'll only say, in a settlement arrived at in Delhi, when I recorded the settlement, one of the parties raised a hand to say something, and contrary to the laws, I permitted him to say. He said, all I wanted to say was thank you, because we were able to sit together and sort out the dispute. I always believe that thank you in that matter gave me greater satisfaction than possibly writing any judgment. As the settlement Mrs. Rampanchu talked about arrived at, or the one you arrived at, I feel it gives a great sense of satisfaction, which is what starting from Father of the Nation talked about and was quoted by Mr. Khanna. That's the way forward. And I look forward to mediation, solving COVID-related disputes and sorting out the disputes which have prevailed over a period of time, with government playing a constructive role in a systematic way. Thank you for giving me this opportunity.
Thank you, Justice Kaul. Thank you so much for elaboratingly discussing about the issue. In fact, Rahul, our technical man, has given me an input. There are more than about 2,500 viewers in this on Zoom, YouTube, and other Facebook and other medias, which includes about 200 plus law students. They are law students, 200 plus. They are very, very encouraging. And law students, that will be encouraging that they will be the next generation who will be coming up to take up these mediations. Now, in the process, they have asked for questions from the viewers, from all the registrants. And Rahul, Sanpreet, with the help of Santan and Rajiv, prepared, we couldn't give a questions to ask an audience from it, but they put up a questions and we put up some compilation. Compilation was prepared, and I would be just shortly giving, though there is not much of the time, but I'll be just putting short questions, which I've said it. One compilation from all the viewers, the audiences. George, are you here? George Lame. George.
Yes, I'm here.
Yes, George. In fact, there is a question which has been compiled, and there is a request that you should respond to that. The question is, which we have compiled it, in a cross-border mediation, in order to implement or enforce a settlement which has been arrived at in between the parties, suppose one party refuses to abide by it, what would be the solution? Do they have to go for an adjudication again, or any other process?
Sorry, can you repeat the first part?
I put it. In a cross-border mediation,
Right.
parties arrive at a settlement,
Yes.
and the settlement is written. Now, subsequently, one of the parties becomes wiser and he refutes the settlement. Now, how to implement and enforce that settlement?
Okay, so thank you for that question. And this is precisely why we had the Singapore Convention on Mediation. Okay, so prior to the convention, if you had a cross-border mediation and it resulted in a settlement, and then one party decides or is not able to comply, you would have to take that. It's just an agreement, a contract. You want to enforce it in that party's country, you have to go to that country and sue on the contract, start new proceedings. So this was the problem we all faced because people said mediation had no teeth. But now, with the Singapore Convention, we are hoping to address that problem. So if that party where you want to enforce, whose country has got that party has got assets in the country where you want to enforce the agreement, and that country is a signatory to the convention, you can take the agreement to that country, to the competent authority there, usually the court, just like an arbitral award, and ask the court to recognize it, to register it, and to enforce it. You don't have to start fresh proceedings. So that's the benefit of it. But the convention is still at a very early stage. It will only come into effect on the 12th of September this year. And we are hoping that with time, more and more countries will sign up, ratify, like India, and then it will become effective. Okay? That's not the fact. It will take some time. But the New York Convention was, I think, was in 1958. Started with 10 signatories, and it took time as well. So we are hoping that more and more countries will come on board. Brian, we had a conversation. I'm hoping you can get the whole of Commonwealth to come on board. I'll hold you to that, Brian. But it will be effective when people come to the table. But, I tell people enforceability is one issue, but the convention actually has promoted mediation all over the world. That is the other benefit, because people are now interested and people are now aware. So I hope that answers the question.
Thank you. There are a lot of raising hands, and the questions are being asked. Sorry for it, because we can't take up those questions because of a shortage of time. But there is another question, which is for Sriram Panchu. This is from Mr. Rajiv Patel. He is a senior advocate, and he is a former chairman of Bar Council of Maharashtra and was a past president of Bar Association. He is asked, this is from Sriram Panchu, whether mediation will replace arbitration in near future? Mr. Sriram Panchu. Sriram Panchu, yes. You have to unmute.
Yeah, sorry. No, I don't see it as, mediation replacing anything. I actually see it two ways. One, I think what I would say is appropriate dispute resolution. Whereas we have different methods of dispute resolution for different kinds of problems. And you take the remedy which suits the malady. You see what does this case need? Does it need mediation? Or is it a complex case which is going to really turn on evidence and it needs therefore expert assessments and a lot of evidence? So it needs arbitration. Or it needs the direction of the court. It needs the interpretation of law. It may need a judge. Need a judge to rectify the imbalance. So it's a question, I think, of assessing each case and seeing what does this case require. And I indeed think that is the first skill a lawyer should possess when he takes a case to a client, is to see, like, what is the dispute resolution remedy I think is best for this client in this case, number one. Number two, I also see the possibilities of harmony between arbitration and mediation. And I think in several cases, it's at critical times or at suitable times, arbitrators and parties can say, well, let's keep the arbitration on hold for a short while and let's try to mediate. And even if they can mediate a portion of their disputes, so much the better. They have reduced the area of conflict. Similarly, I think that sometimes in a mediation, you cannot resolve that dispute through mediation. The parties may well be amenable to having a short, time-bound, specified arbitration with an arbitrator chosen there and then on the spot, so that you can finish off the dispute within a short while, rather than go back to contentious fighting on who should be the arbitrator. So there are ways, I think, of creatively, connecting, merging the two, using synergies. So I like to look at it in that way. We're talking about a synergistic use of different processes of dispute resolution, rather than competing and replacing.
Thank you, Sriram. Thank you, Sriram. There is one more question to Brian. Brian, Brian, for you, there is a question. The question is, which we have compiled, is how far the accreditation and the continuous education is helpful in mediation movement. This is from the law students. They want to emphasize.
Well, that's really important, and one of the things that will change the attitude of the legal profession generally is if mediation becomes part of the training of law students. They will grow up as simply that's part of the range of tools in their legal toolkit, and if it's not taught, and if it isn't taught pervasively across the curriculum about how to fulfill your obligations to your client and to advise them of the most appropriate approach to the resolution of their dispute. That is the calling of lawyers, to act in the best interests of your client. And without training at law school and without continuous repeat training in CPD or continuous education programs, that can be lost. So a reinforcement of skills, a development and an enhancement of skills, and a flexibility of response, such as the COVID pandemic has taught us all to use these virtual conferences. So I'm very, very keen that we introduce in our law schools that when analyzing disputes and encouraging people to develop skills of negotiation in the interests of their clients, mediation must be very much part of that. Jitendra, if I might, there was a comment made by George in his answer about enforceability. And I know for many lawyers, there's a big concern about enforceability. For many mediators, it's less of a problem because the process itself, having involved the parties creating their own solution, is often self-enforcing. The parties have made their resolution and therefore feel, if you like, connected to it in a way that a solution imposed by a court is less impactful. So we find enforcement is more a concern in theory than in reality. And I wanted to make simply that point. And while I'm speaking, I did want to mention how much I enjoyed Justice Cowell's comments, who I understand from my friend Santan is a former attender and delegate to our Commonwealth Law conferences. And it's great to have that support and to hear such wisdom from a senior judge on this topic of mediation. So thank you for making those additional observations. And I'm sure George maybe wants to come in on the enforcement issue. George, is that it?
May I, Mr. Chair?
Yeah.
Thank you. So I think Brian has made a good point. In fact, we had this conversation because the good mediators will tell you that if you structure a settlement, a mediated settlement properly, and you explain to the parties and you ensure that they can comply, possibility hopefully is not a problem. And in the vast majority of cases, it is not. But we do have a fraction of cases where things don't turn out the way people plan. For example, we've done cases where the guy promises to pay, but later on he's got some other claim and he can't pay. So in a small fraction of cases, you do need the enforceability mechanism, and we recognize that, and that's why you have the convention. But the other reason is this, because when we go to parties and the businesses and ask them to mediate, a lot of them ask this question, is it enforceable? And it's a fair question, right? Because if you are party to a contract, you want it to be enforceable, you need to. And if you tell them, look, it's not enforceable, they will not want to mediate. So this is the other impact, the other effect of it. It brings people to the table and it gives confidence to parties that if something goes wrong, I can enforce. And that helps the promotion of mediation as a whole. So for me, that is how I will explain it. And that's why the convention is important. It's not about Singapore, okay? It's about promoting mediation globally and giving it teeth. I think will propel mediation forward, just like the New York Convention has done for arbitration.
Thank you, George. Thank you, George. Now we are no more questions. We'll be concluding part. I'll be just showing one slide about the mediation. Rahul, can you show the slide? About mediation, Mahatma Gandhi has been always referred throughout the world as a mediator, amongst the one of the few first mediators, or who is said to be stated about the father. Now, this is a document which is of 16th century, and it is, though it is in Hindi and Farsi, it is in the Allahabad High Court Museum, one of the largest high court in the country. This is a document whereby Tulsidas, the Ramayana, the one who wrote Ramayana, Ramcharitmanas, he was appointed as a mediator in a family of Todarmal, one of the ministers of late King Akbar, and the matter was resolved between the parties. So this is the document which says that the first mediation settlement is a written document which we have, and it is preserved in Allahabad High Court Museum. I got a copy from them. I'm grateful to the judge who has sent me the copy. I put it there. Now thank you, Rahul. Now this session comes to an end, and may I now request Rajiv Datta to propose a vote of thanks. Rajiv. Rajiv?
Yes, can you hear me?
Yes.
As all good things must come to an end, friends, it is the time which brought us together, and it is also time that we leave it for future to discuss more aspects of mediation. Honorable Mr. Justice Sanjay Kishan Kaul, who is the spirit behind mediation in the high courts where he was, and now in the Supreme Court. We are privileged, sir. Mr. Brian Spears, Mr. Sriram Panchu, George Lim, and all the participants. It's my proud privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of the organizing committee, express my sincere gratitude to the eminent speakers and also who have agreed to participate despite their very busy schedules. I am sure, like me, all of the participants have gained a lot today. And also, let me put it that from the from the point of view of a Supreme Court judge to a great mediator and also across seas, everyone sitting at home has now got so many inputs as to the mediation now becoming a global phenomena. And during the COVID period, it is something which has come about that it is now time that online mediations, which are already there in India and elsewhere, should now take over in the future. Let me also take this opportunity to thank some Sanpreet Singh Ajmani, who is a young, enthusiastic mediator and a leader in his own right, for having agreed to and do all the work that he has been able to do for us. And also, let me also thank Mr. Rahul Kumar, who is our technician, who did so much work to bring us all together. And in the end, I can only say that think out of the box, and that is what Justice Call has said, and that is something that only can be done by mediation. Mediation now is awaiting the legislation in India, and at the Supreme Court, I can assure you, we are now in a very steady. We are having a very steady state of affairs. We are progressing in a very fine manner under the aegis of Justice Call, and I at the end, it is only this, that we take this forward. And as all of you have said, that online mediation has come to stay. I think all of us have gained a lot of knowledge today, right from the beginning of how Mr. George started, that how hugely mediation has grown in India. And then Sriram Panchu also putting in his words, and also Mr. Brian Spears. Thank you very much for indeed for sparing your time. And Justice Call, we are always indebted to you, and we shall remain indebted to you for all the encouragement that you have given to us. Looking forward to our great future of mediation in Supreme Court. Thank you, sir. Thank you very much.
Thank you so much.
Thank you.
Thank you, Rahul. Rahul?
And I almost forgot. I think it is a very important thing for me to mention that the law students who have joined us, and I think it was mentioned that it is now going to be a part of a curriculum, that we train the young budding lawyers right from college into mediation, so that they don't have to wait for a long time into their litigation practice and then start mediation. Thank you very much to all the young lawyers, budding lawyers of the future.
Thank you. Rahul. Rahul is not only a technician, but he is a law student, a final law year.
Oh, great.
Thank you. Thank you. Rahul, you can put everybody off. If you can put us only speakers together, is it possible? ऐसा हो सकता है कि हम केवल speakers रहें, बाकी off हो जाएं?
Yes, sir.
1 minute before we put off. हो गया? राहुल?
Yes, sir.
बाकी सब off हो गए?
Yes, sir.
Thank you, sir. Now we must give a thanks to Justice Paul. We are only.
Thank you for it. Was very interesting listening to a perspective across countries, and
Yes.
the fact that there's a concern, I think, is very important. That all of us are in some way a little worried that post-COVID situation, what will happen to the beyond litigation which will arise, and the requirement of early resolution of all these problems. They should not become another set of areas. And we are not only talking about that, but I was reading yesterday, say in countries like England and other places, also there is a concern that with courts not working to normal capacity, with disputes being kept at bay for some time, suddenly there'll be a deluge. And as the word used by George Graham was tsunami, it can be a deluge, it can be a tsunami, it can be an earthquake. Let's prevent the tsunami and the earthquake. And the only way I can say it, I don't think any litigation system can be able to take this volume unless we approach mediation. So mediation requirement has grown manifold because of what the post-COVID phenomena will be.
Yes.
Thank you.
Thank you, sir.
Thank you, sir.
And it's a great initiative. The thread is
Yes.
Santan. Just like all pearls are being under the one thread, the Santan is the guiding force for bringing everybody
I think
together.
Rakesh, Santana, all of them have taken a lot of initiative to get
Yes, sir.
everybody together.
Yes, everybody is.
And
It's a whole team effort, sir.
Team effort.